I'm Michael Pitt. I'm the dinner chairperson, and this is our third annual ACS Michigan chapter dinner. And I welcome everyone today to this event. I'd like to take a few moments and acknowledge our dignitaries and our board members. Let me start with Walter Shapiro, of the bankruptcy judge from the Eastern District of Michigan. Walter's here. Thanks, Walter. And the Honorable Ed Ewell. Hi, Ed. The Honorable Carol Youngblood. Hey, Carol. Is referee David Perkins here? Yes. Hi, David. The Honorable Marianne Batani from the U.S. District Court, Eastern District of Michigan. The Honorable Elizabeth Gleischer from Michigan Court of Appeals. I saw her. And we have also the Honorable Marilyn Kelly, Michigan Supreme Court Justice. And Marilyn, will you stay standing? And sitting next to her is the Honorable Diane Hathaway from Wayne County Circuit Court. And don't they look great together, the two of them together? Isn't that a wonderful sight? Look at that. That is a great sight. So keep that in mind, will you? Don't forget that sight. We all want that sight to continue for indefinite, for a long time. We hope to see those two together for a long period of time. Professor Gary Mayville is here. Professor. And Barb McQuaid is our president-elect of our chapter, also president of the local chapter of the Federal Bar Association. Barb. I think that does it. And of course we have our keynote speaker, the Honorable Abner Mikva. Oh yeah. The Honorable Cynthia Stevens from the Wayne County Circuit Court is here. Hi, Cynthia. And I'd like to have our board members stand and be recognized. Jocelyn Benson, would you stand? Jocelyn's here. Professor Benson. Andy Doctoroff and Mike Elkins. Dave Greco, John Jacobs, Valerie Newman, Tom Rombach, Abe Singer, and Roger Walcott. And I'd like to give a special thanks to Kathy Chisholm. Kathy, would you stand up? Kathy has pretty much single-handedly put together all the details and logistics of this wonderful event, and this is the third time she's done it, and we really appreciate it. So thanks, Kathy. I'm going to, before I turn over the podium to the National Executive Director, Lisa Brown, I just want to make a few comments about the season that we're in. The national elections are upon us, and as lawyers and as friends of lawyers, we need to take a special interest in making sure the democratic process works. And I encourage each of you to become engaged in the electoral process as it unfolds over the next 30 days, 60 days, 30, 40 days, I guess, about 40 more days to go. There are many things that we can do as lawyers that would make a difference. Naturally, we can get behind the candidate of your choice and help that candidate get elected. You can also work the polls. And there are many of you here that have worked the polls, trying to make sure that the election laws are adhered to and followed, and that everyone who comes to the polls has a fair opportunity to vote. And this year it's especially important because this is the first year that the photo ID law is going to go into effect. And there are going to be a lot of people coming to the polls without photo IDs. And as lawyers, we know that they can still vote. That they don't need to have a photo ID to vote. They can sign an affidavit. They can do any number of things to get in and vote. And lawyers need to be at the polls to make sure those laws are followed. There's going to be a lot of opposition to people voting this year. There are going to be challenges, and progressive lawyers need to be on the ground working those polls to make sure that every person that comes to the polls gets a chance to vote. Right? Mary Ellen has given me lawyers and law students voter protection, and if you like, come by my table and put some up. It's really important that lawyers take an active role and just stop. And you got to talk the talk and you got to walk the walk. And if we're going to be progressive lawyers, as we are, we got to make sure that everyone has an opportunity to exercise their constitutional right to vote. So with that, I'm going to turn this over to Lisa.
Thank you, Michael. It's great to be here. I always so look forward to this dinner. It every year sort of rededicates me to our joint cause because the energy of this chapter is so tremendous. And so I'm thrilled to be here. And once again, you all have put together a spectacular evening. And I won't repeat all of the acknowledgments, but I do want to say a particular welcome to the new board members of the chapter. All of them are listed on the back of the program, and most of them were just acknowledged. And we're thrilled to be working with you, and we are here to serve all of you. So please let us know what we can do to support your efforts. And I have to, in particular single out Michael Lee, the chapter president, the former president Tom Tallarico, who we've been working with for a couple of years now, Michael Pitt, who has chaired this dinner for 3 years in a row. There's a real base to this chapter, which is absolutely spectacular. And then President-elect Barbara McQuaid. We're really thrilled to be working with you in the near future. You guys have yet again organized a star-studded dinner, and with both local hero Judge Keith as your honoree and Judge Mikva as your keynote speaker. What many of you may not realize is that Judge Mikva is actually one of the founding fathers of ACS. He is literally one of the people that was involved in founding this organization 7 years ago. And since I have the privilege of the mic right now, I want to say a couple of things, because in many ways Judge Mikva really emblemizes the values that ACS is all about. And you're going to hear a lot about his stellar biography later on this evening. But what I want to highlight is the extent to which in all of the terrific jobs that he has held, he has been a steadfast champion of the values that are at the core of ACS: liberty, justice, equality, and the rule of law. If politics were like picking stocks, Judge Mikva would be the Warren Buffett. And his roots are deep, his character is unimpeachable, and his eye for justice does not err. He has always done what was right without regard to potential short-term political costs. And that began when he was running for office, taking on the Chicago political machine in the name of good government and progressive values, for which then Mayor Daley rewarded him by redrawing the electoral districts and gerrymandering him right out of his congressional seat. And similarly, when he took on the NRA rewarded him by spending the most money they had ever spent in opposing a congressional candidate. In each instance, he ended up proving that he was right and prevailing. And so, that core determination and commitment to what is right has always been what, to me, Judge Mikva really stands for. And he also has had foresight about issues, been ahead of most of the rest of society on issues that really matter. And long before anybody contemplated the term enemy combatants, much less that we would be in a place where people were being held without charge, without lawyers, Judge Mikva actually recognized the potential for executive abuse based on the treatment of civil rights protesters in the 60s and the treatment of Japanese Americans in the 40s. And as a freshman congressman in 1971, he convinced Congress to pass a law providing, quote, no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. And it was that law which gave the Second Circuit the power to order that Jose Padilla couldn't either had to be charged and tried in civilian court or released from a military brig, and thus to prevent precisely the types of abuses that the Bush administration has perpetrated in the name of the war on terror. Also, in the 1990s, when he was chief judge of the D.C. Circuit, Judge Mikva wrote a, sadly at that point, short-lived decision recognizing the essential dignity and rights of gay and lesbian service members. And the case was overturned a couple of years later, but his views about the Fifth Amendment were vindicated 10 years later when the Supreme Court handed down Lawrence v. Texas. So this is the man that is our keynote tonight, and I have to add that he also happens to be a great mentor, or in Chicago I think they sometimes say godfather, to young progressive politicians who share his vision of a just society. A certain skinny law professor from the south side of Chicago happens to be one of those that is better known, but he has many other political protégés who have done an awful lot to make our society more just and true to the values that we are all about. So no better person to keynote this evening. Michael mentioned this election, and on the eve of this historic election, I can't help but contrast this evening with the time 7 years ago when ACS was founded, which was on the heels of the Bush v. Gore decision. And progressive lawyers had essentially woken up to the success of the conservative legal movement and were eager to take action. We knew what was at stake, and we were determined to revitalize the progressive values at the core of our Constitution. What we could not have known then was how much further our country would stray from the core values of liberty, justice, equality, and the rule of law before it would get back on course. The specific damage done to the administration of justice, the lives of Americans, and certainly our national reputation is well documented and well known to all of you. But the opportunities before us to change all this are tangible right now. And on the eve of an election that has re-engaged people, young and old, in our democracy, everybody is thinking about the future. Our founders recognized that freedom, justice, and equality weren't going to be handed to us by those in power. That those are things that were always going to have to be fought for vigilantly by all of us. And the question is now directly before us: what kind of country do we want this to be? And what are we each going to do to realize that vision? Will we restore the checks and balances so fundamental to our democracy, respect human rights, and follow the rule of law? Will our courts play their historic role as the ultimate protectors of justice and be open both to individuals in U.S. custody abroad and to consumers and workers here at home who have suffered discrimination or other injury? Will Department of Justice policies on priorities ranging from counterterrorism to civil rights to criminal enforcement, not to mention their own hiring practices, be impartial, principled, and based on the rule of law? Will we protect and facilitate, as Michael was talking about, the fundamental right to vote? Will our federal government protect workers, consumers, and investors, help people in times of crisis, and safeguard our environment for years to come? These are key questions facing all of us today and on the eve of this election, and it's time for each of us to step up and fight for our vision of America. And ACS is here to help you do just that, to make sure that your voices help shape the face of our democracy this year, next year, and in the many years to come. ACS is a potent voice and growing resource of ideas and person power for all of you who are working to build a better future at the local, state, and national levels. And our strength stems from two things: the power of our ideas and the energy of our growing progressive legal network, both of which things you all are integral to building. Just to give you a sort of big picture of the organization, through our national programs, which is now we have an annual Supreme Court review at the Press Club in Washington, regular press briefings, regular briefings on Capitol Hill or convention. We're disseminating compelling leaders on the national level to decision makers and opinion leaders. Just as important are the over 1,000 programs a year we now host around the country that our student chapters and 164 student chapters and 30 lawyer chapters host. Those are the programs that you all host that are highlighting on a local level the key local and national issues that are facing our country. We are generating and publicizing compelling ideas through our working groups and publications. We now have 9 working groups on issues ranging from democracy and voting to economic and environmental regulation, from access to justice to separation of powers. And 2 journals, the Harvard Law and Policy Review, which is the official journal of ACS, and Advance, which is the journal of the ACS issue groups, as well as ACS blog. And our ideas range from the most practical, identifying priorities for the new administration in the areas of law and justice, to the most intellectual, synthesizing and publicizing an approach to constitutional interpretation that gives meaning to its core values. So just to give you a sort of current taste, a new study that was it will be released in the ACS Journal in January, showing how badly employment discrimination plaintiffs are faring in federal court right now, was the subject of a Senate Judiciary Committee hearing last week that Senator Leahy chaired a week after its release. We hosted the release of it and then worked with him to host the hearing. And our Harvard Journal just published a series of papers essentially talking about how to bring justice back to the Department of Justice and the Civil Rights Division, the Criminal Division, depoliticizing it. And our next volume of Advance is going to include a wider range of transition papers. And of course, we continue to build a network of current and future leaders who are equipped and determined to improve the face of this country and have the country live up to the best promises of our Constitution. So it is certainly time to reclaim our Constitution, to embrace the progress we've made, to take it even further, and to give law back its power for improving the lives of all people. Our first self-expression as a nation begins with the words, "we the people," which to me shows exactly where responsibility resides, and that's in us. It is our responsibility to be engaging in this dialogue right now. We're the ones who are going to determine the future course of our nation, and that is especially true of lawyers. So thanks to your hard work, ACS is ready to help you engage. We're here to do just that. Through ACS, you have access to compelling ideas and people, and I hope this will enable you to keep the energy of this election going for many, many years to come. But to realize this vision that we share, we really do need each of you to be actively involved in ACS. So most importantly, I want to say thank you all for coming tonight. You all really are the heart and soul of ACS. And I hope you will not only continue to expand the influential network that you have built here in Michigan, and we have membership forms actually outside for if there's anybody here who is not yet a member, we hope you will join. I also hope you will get involved in the organization, not just here in Michigan, but also on the national level, and help us convince others of the power of our ideas. Speak at an ACS program, write a paper for one of our journals, contribute to our blog. It's all about communicating the power of our ideas. And in short, it's going to be through your efforts, your ideas, your writings, your actions that we are going to bring about real change in law and policy in this nation, and hopefully make it more true to the vision of our founders of liberty and justice for all. So thank you for being here and for being part of ACS. So Tom, are you...
Good evening. I'm Tom Tellerico, and I've had the privilege of being the president of this organization for the last year. For those of you who don't know this, I'm just going to give you a quick history of the local chapter. Although the organization has been around nationally for about 7 years, this organization, the local chapter, which is, as I understand it, the first official lawyers chapter in the country, at least with the Constitution, was only formed a little over 2 years ago. In that brief period of time, we have, first of all, managed to assemble a board which I think is very distinguished. Among other things, on the current board, we have a person who is the current president of the Federal Bar Association and past presidents of the Federal Bar Association. We have a person who is the current president of the State Bar of Michigan, and other people who are past presidents of the State Bar of Michigan, among many other accomplishments. In this brief span of time, we've had 3 annual dinners, one in 2006. The 2007 annual dinner was actually in early 2008, for reasons I will not go into right now. But this is now our 3rd annual dinner, and we plan to have them in the future probably about this time of the year. I will take responsibility for having pushed the idea of doing it right now, and so we have run into some conflicts with the political season and holidays and that. But we will almost certainly plan dinners in September or in the fall in years to come. At those speakers, we've had the good fortune of having Governor Granholm speak, Senator Levin, and tonight Judge Mikva. We've had the privilege of honoring former Governor Milliken, current Congressman John Conyers, and tonight Judge Damon Keith. In addition, we put on a number of programs, and I would like to tell you just a little bit about them because I encourage you to come to them in the future. They've been a wide range of programs, going from a 3-hour seminar at Wayne State University, which I'm going to tell you a little bit more about in a minute, and symposia on a number of subjects. We've even had a debate between former U.S. Attorney Jim Robinson and Judge Whitbeck on the Court of Appeals. We've had speakers ranging from Carl Levin to Avery Cohn to Judge Whitbeck to Professor Mayville from the U of D, Justice Kelly, Professor St. Antoine, Mary Ellen Gurwitz, Jim Robinson, and many other nationally recognized speakers. We've had those events in Detroit, Southfield, Dearborn, Troy, and Birmingham. We've had them at lunch and at dinner, and we hope that you will join us in the future on other programs. The next program will be Judge Mark Goldsmith from the Oakland County Circuit Court, who I believe is going to speak on November 11th, either at lunch or dinner. But those of you who are on our mailing list will receive an announcement, and those of you who are not should get on our mailing list. We're proud of all of this, but I want to tell you a little bit more about 2 things. First of all is the program at Wayne State University. In March, we put on a program that was entitled The Impact of the Michigan Supreme Court on the State of Michigan Law, 1999 to 2007. Dean Wu, the then Dean of the Wayne State University, Mary Ellen Gurwitz, Catherine Rizalski, Associate Dean Mayville, and another professor from U of D, Jeff Silver, Mark Ronzato, Doug Shapiro, Michael Lee, Michael Pitt, Michael Elkins, all spoke at that and gave a presentation on various substantive areas of the law. We were also privileged to have Justice Kelly there to give her some concluding remarks. We covered a wide variety of topics, and I should tell you there is a paper out in the hallway if you want to pick it up on the way out, which lists the speakers, lists the topics, and lists all of the cases that we discussed at that seminar. But without going into the specifics of the substantive topics, let me tell you that the overarching point of that seminar was the following, and that is whatever your political or social views, whether some of your clients have benefited from the decisions of this court or not, I think most of us would agree that the law can and should provide some kind of a steady influence to guide us. You don't go around reversing 5 major precedents a year, including precedents all the way back to 1 Mish, which is what the current court has done. Stare decisis is important, but it has effectively been overruled by the current court. That was the theme of this seminar, or in Justice Kelly's words, it has been thrown out the window. As Dean Wu said at that seminar, the breadth and depth of change affected by this court is unprecedented. And noting that the majority had totally ignored judicial restraint, Justice Kelly said, the only remedy for this is increased voter education, which, she noted, is crucial to making the election of judges more informed. In that regard, I note that Brian Dickerson was at the seminar and has told us he's going to run a series on the subjects we spoke about. And we certainly hope that will help educate voters. We also have available tonight, I only have 25 copies, but if you want a copy of the whole DVD, if you really think you want to watch it, we'd be pleased to give them to you. Either see me or Jill Dash. And as I said, please take a copy of all of the cases we have cited from that seminar. All in all, I think this has been a very good year. Let me note one other thing that is upcoming, however, and that is in next spring, and I don't think we have a date yet. Let me explain that for the last several years, the national ACS has put on a moot court competition which is held in Washington immediately before the national convention. Students from all over the country are invited to attend. Before the national competition, there are 2 regional competitions. The country is divided roughly in half, depending on where the students apply from. This year, the University of Michigan chapter, the student chapter, has applied and been granted the right to put on one of those regional chapters. Before National agreed to grant them that, they called us and said, you realize, of course, that we expect the lawyers to produce the judges. So we have volunteered all of you for next, I think it's March or April, we'll give you an exact date. Those of you who have participated in a moot court competition know that it's a lot of fun, and I certainly hope that you will all participate. Thank you all for coming, and enjoy your dinner.
Good evening.
Good evening.
Well, all of your nice socializing is over. I'm back, so. It is my honor to introduce the awardee for the Governor William and Helen Milliken Award. When we decided to create an award, we talked a little bit about who would personify it and after whom could we name it. And it became apparent to us that Governor William Milliken and his wife Helen were the ideal individuals because, irrespective of political affiliation, we thought that they both showed a progressive spirit, great intellect, great courage, and the ability and willingness to reach out to people all across the state, irrespective of their backgrounds. And so we named the award after them. Now, Governor Milliken would like to have been with us tonight. Unfortunately, he recently lost his brother, so he's unable to be here. But I talked to him yesterday, and he sends his congratulations both to the organization and to the awardee, Judge Damon Keith, and he wishes us all the best. So Judge Keith could not be here either because he is doing something in 2 different states this week. But he was kind enough to fit me in about an hour and a half before his flight left. So I charged over to his chambers with a videographer. And I always travel with a videographer, as all of you know. And he gave us about 10 minutes of his time. So without further ado, we would like to show you that brief interview. Good evening. I'm Michael Lee, and I'm the president-elect of the American Constitution Society Michigan Lawyers Chapter. I'm here today to present the award, the Milliken Award, to this year's recipient, the Honorable Damon J. Keith. As you all know, the Milliken Award was named in honor of former Governor William Milliken of Michigan. Governor Milliken was Michigan's longest-serving governor, served for 14 years, having been elected for 3 terms in 1970, 1974, and 1978. Despite the fact that Governor Milliken was from a rural area, he didn't hesitate to reach out to constituencies from other areas of the state, other ethnicities, and even other political parties. So when we decided to create an award, we thought there was no one who personified what ACS Michigan stood for better than Governor William Milliken and his wife Helen Milliken. This year's recipient is the Honorable Damon J. Keith. Judge Keith needs no introduction for any of us. We know him. He is, in fact, the father of Michigan lawyers. And we thought it was most fitting that we honor him at this time. Judge Keith is a native of the city of Detroit. Judge Keith is a graduate of West Virginia State University, Howard University Law School, and achieved an LLM from Wayne State University Law School. Judge Keith served in the armed forces in the Army from 1943 to 1946. He was in private practice from 1950 to 1964, and then with the firm from 1964 to 1967. Judge Keith was appointed to the United States District Court for the Eastern District of Michigan in 1967 and served on that bench for 10 years. Judge Keith served as the Chief Judge of the Eastern District of Michigan from 1975 to 1977. In 1977, Judge Keith was elevated to the Sixth Circuit Court of Appeals. He served on the Sixth Circuit Court of Appeals from 1977 to 1995 and took senior status from 1995 and presently serves as a senior judge. Judge Keith has a distinguished legal career, but an even more distinguished career outside of the law. Judge Keith has shown great courage on the bench and has never shrunk from conducting his responsibilities as a judge. For example, Judge Keith's most famous decision is United States versus Sinclair, in which Judge Keith ruled that even the President of the United States could not conduct warrantless wiretaps. It seems like the more things change, the more things stay the same. But that was a great, courageous moment. Is there anything you'd like to say about that particular case?
Well, I am delighted, number one, to be the recipient of this award. I was the national chairman of the bicentennial of the U.S. Constitution. I was appointed by Chief Justice Rehnquist, and all the federal judges in the country were under my jurisdiction and supervision as we celebrated the bicentennial of the U.S. Constitution. And I'm happy to say there are about 300 Bill of Rights plaques in almost in every federal courthouse in the United States, and in the Thurgood Marshall building, FBI headquarters, demonstrating the Bill of Rights plaque with my name as the chairman on it. So I have a strong commitment to the Constitution and to the Bill of Rights. And so Governor Milligan and his lovely wife Helen certainly symbolizes during their lifetime and now equal justice under law and what that means in terms of our democracy. Governor Milligan had a total commitment to the city of Detroit. He and the late Coleman and Alexander Yellowworth were good friends, and Governor Milligan said that we've got to keep Detroit viable and keep it a place where people will want to come. And whatever he could do as governor of the state of Michigan, he wanted to do it to help the citizens of Detroit. And I believe that it was Governor Milligan, I'm not sure, who saw the necessity of bringing state troopers into the city of Detroit to patrol the highways and things like that. He just felt as though it was a part of the duty of the state to do this. So he symbolized everything that the Constitution means. He was a modern Republican, and I don't know if there's any room now, and I'm not talking politics, for a man who is a moderate Republican to have a voice in that party. But anyhow, I want to congratulate him and say how deeply honored I am to receive this award named after a good friend of mine and a man who I admire a great deal.
Now, as I said, the judge has a tremendous record of accomplishment on the bench as well as off the bench. There is, in Wayne State University, the renowned Damon J. Keith collection. Can you tell us, Judge, about the importance of legal history and creating this collection so those who come after us can know the work and know the law?
Thank you very much. We do have the Damon J. Keith Law Collection of African American Legal History. It was started and had its kickoff affair at the Thurgood Marshall Building in Washington in 1999. President Clinton was there, and Mrs. Thurgood Marshall and Rosa Parks. It's a history and a chronology of the 14th Amendment, the Equal Protection Clause of the 14th Amendment, and has a development legally of the struggle from Brown versus Board and before, and then after Brown versus Board, with men like Thurgood Marshall, Charlie Houston, Bill Hasty, Jim Nabert, Oliver Hill, and those great pioneers for the NAACP who used the 14th Amendment and the Equal Protection Clause of the 14th Amendment to break down segregation. And this exhibit has traveled all over the country, at Harvard and law schools and the federal building in New York, in Chicago, Cincinnati, with the Bill of Rights plaques there. So we thought it was important as lawyers and citizens that we convey this message through an exhibit. And President Clinton, after seeing it in Washington, wrote me back and said it was one of the finest exhibits that he had ever seen.
Now, in 1998, Judge Keith received the Edward Devitt Distinguished Service to Justice Award. And at the time, Federal Court of Appeals Judge Peter Fay said the following: "One cannot be around Damon for very long without sensing his commitment to all that is good about our country. But unlike many, he does not limit his commitment to words. His actions speak volumes. He gets involved. He spends the time. He does the work. Yes, he gets his hands dirty, because there is nothing he will not do if he is convinced it will help others and strengthen our way of life." I think I speak for all of us when I say we wish we had many more Damon Keiths, but deep down we know there will never be another Damon Keith. Once again, Judge, congratulations, and we are honored to honor you.
Thank you. I'm deeply honored to receive this award, and I'm just sorry that a commitment outside of the state permits me for not being with you on this occasion, and I'm sorry about it.
No apology necessary, Judge. Thank you.
We go on there?
Lest we think that Judge Keith has mellowed, having taken senior status, after that interview, he gave me a copy of a dissent he wrote in a habeas case, Tucker versus Palmer, in which both a federal magistrate judge as well as a federal district court judge had granted a habeas petition on behalf of an individual who was convicted in a state court case, a bench trial case in Wayne County. The Sixth Circuit reversed, and I'd like to give you a few excerpts from that decision. He begins by saying, quoting the old sage words, that it's better that 10 guilty persons escape than that one innocent suffer. And then it gets a little less gentle from there. He says, "It is truly sad that the majority does not feel the need in the Constitution to recognize the presumption of innocence and is refusing to recognize that speculation of guilt must never trample over the rights of the accused." He further says, "I shall not and will not idly stand by as the majority condones and facilitates this miscarriage of justice. I am saddened and outraged, and in fact embarrassed for our judicial system, that this case has reached this point, that this court could affirm a state trial judge's conviction and sentence of 7 to 15 years in prison without a semblance of evidence of wrongdoing is a pathetic and dismal reflection of our judicial system." And in case the majority had any doubt about how he felt, let me finish with these words. "Apparently neither the state trial judge nor the majority ever read or understood the Constitution. For in the instant manner, they recklessly disregarded this fundamental requirement of proof beyond a reasonable doubt by convicting the defendant of home invasion without any evidence sufficient to prove his guilt.
After I read this, I said, well, Judge, it appears that you do still have the fire, and we are all better for it. Once again, please join me in recognizing Judge Damon Key. It now falls to me to introduce my predecessor, President Thomas J. Tellerico. Tom has got the kind of practice that most of us only dream about. I don't know how it is he was able to perform his duties with the nature of his practice and the extent and distance to which he travels. Tom is admitted in the bar in Michigan and in the District of Columbia. He has a bachelor's degree from Sacred Heart Seminary College and a JD from the University of Michigan Law School. He is a member of the State Bar of Michigan, the International Law Section, the International Bar Association. He sits as an arbitrator for the American Arbitration Association, and he is presently treasurer of the Oakland County Bar Foundation. Tom is also a civil mediator and works in the community as a member of the advisory board of Big Brothers and Big Sisters of Metro Detroit. Tom has handled cases concerning matters in Belgium, Luxembourg, Holland, Germany, Lebanon, Spain, Portugal, Japan, Puerto Rico, and the U.S. Virgin Islands. Can't find any work locally, I guess. Tom has also handled disputes involving citizens from Switzerland, France, Italy, England, St. Martin, the Cayman Islands, Dubai, Hong Kong, and Canada. And I know this to be true because Tom tells us about his travels there and the culture there and things he experiences when he goes to these places. I wish I could travel that kind of way when I'm practicing, but I can't. Prior to joining the firm, Tom is a partner in Bodman LLP. He worked for the Bureau of Economic and Business Affairs of the United States Department of State. He is reasonably proficient, whatever that means, in Spanish and French. Tom has also received several honors, including the Legal Eagle Award from Franchise Times, listed as Best Lawyers in America in 2008, listed as a Michigan Super Lawyer, and is listed in the Benchmark, the Definitive Guide to America's Leading Litigation Firms and Attorneys. I've had the honor and the pleasure of working with Tom on the ACS board for the last 2 years, and there is not a more down-to-earth, more sensitive, more feeling, more true to our cause person who holds such a lofty position in the state of Michigan. Tom truly feels the mission of ACS. He has truly been a great president, and without his help, this chapter would not have been successful as it has been in its infancy. So I would like to publicly thank Tom, call him forward to the podium, and ask you to help me thank him for all the work he has done for this chapter and for lawyers in general. Ladies and gentlemen, the President of the American Constitution Society, Tom Tellerico.
You're all here to hear Judge Mikva, so let me just say the following. First of all, I want to thank Jessica Cooper for suggesting that I get involved in this organization and for suggesting that I run for the board. I want to thank all the members for electing me, the members of the association. I want to thank all the members of my board for electing me to this position, which I have truly enjoyed. And I in particular would like to thank my law firm, Bodman, for having supported me as much as it has. It has really helped us be where we are today. Thank you.
Congratulations, Tom, and thanks for a great year. Well, it is my privilege to introduce our keynote speaker tonight, and I'm honored to have that opportunity. Our speaker, of course, is the Honorable Abner Mikva, who I had a chance to meet earlier this evening, a very warm man. There's a great story about Judge Mikva. As a law student in Chicago, he decided he wanted to get involved in politics, so he went down to his local ward chairman and said he wanted to get involved in the campaign. And the ward chairman said, "Well, who sent you?" And the young Mikva said, "Well, nobody sent me." And the ward chairman chomped on his cigar, and he looked at him, and he said, "We don't want nobody that nobody sent." So the young mikvah was on his way, but he was not deterred, and he got involved in public service anyway, and we're very glad that he did. He has made a career out of making sure that democracy has room for everybody, and especially the people that nobody sent. Judge Mikva, as you probably know, has had a very distinguished career in the U.S. House of Representatives. He served as the Chief Judge of the D.C. Circuit Court of Appeals and as White House counsel to President Bill Clinton. Judge Mikva currently teaches at the University of Chicago Law School, his alma mater, and he also directs the legal aid clinic there. And as Lisa said earlier, we're very pleased that he has been a longtime supporter of the American Constitution Society and serves on the board of advisors for the American Constitution Society. Judge Mikva encountered another man that nobody sent in the early 1990s when he offered a clerkship to a law student by the name of Barack Obama. And the young Obama declined the clerkship to take a job as a community organizer in Chicago. I don't know, it sounds like a bad decision to me, but I hear this Obama guy has done okay for himself. We are very proud to have with us tonight the man that nobody sent. Please join me in giving a warm reception to that man, the Honorable Abner Mikva.
Thank you very much, Mr. Quinn McQuaid, for that very generous introduction. And thank you, Lisa Brown, for your kind remarks. I can't tell you how proud I am looking out at an audience like this of ACS. I think I sort of feel the way a father feels after all the college bills are paid and he's looking at the success of his progeny. When we started, and there were a lot of others involved, but when we first started with the idea of an organization like the American Constitution Society, we frankly admitted that we were trying to emulate the Federalist Society. We had become nervous and depressed and concerned about the influence, the growing influence that the Federalist Society was developing, not only in using its experts and its expertise in interpreting the Constitution and basic laws of the United States, but in terms of planting people in key positions. There was a time, and perhaps it's still going on, not for much longer I hope, where without a Federalist credential you almost could not get a top legal job in the administration. You couldn't seriously be considered for a federal judgeship or any of the other places where lawyers are needed to make the important policy decisions of this country. And in the 7 years that ACS has been around, we've more than accomplished that initial purpose of the organization. We no longer have to try to emulate the Federalist Society. I think at this point we have to accept that, particularly with a new administration coming up, and hopefully with one that will look more kindly on the American Constitution Society as a source of ideas and personnel, that we have an important responsibility to right some of the egregious wrongs that have been done to our legal system over the past 8 years. So I'm especially pleased to see this crowd and to hear how well the Michigan chapters of ACS are doing, and to know that you're a part of what has become a very, very important organization in the legal spectrum. I want to try to walk on a tightrope tonight. I want to talk to you about lawyers as presidents. Now, that could be a nice historical subject if I were willing to just give you dates, and chapters, and places, and how long Calvin Coolidge served. Yes, he was a lawyer, I regret to say. But I'm going to try to do more than that. I'm going to talk about the substance of lawyers as presidents. And I'm going to try to be nonpartisan, or bi-Protestant, as Mo Udall used to say. I recognize you're a 501c3 organization, and I don't want to get your charter in trouble, and I certainly don't want to step beyond the pale as far as my audience is concerned. So if I overstep at any point, forgive me. but I will try to remain nonpartisan. I'm reminded a little bit of what happened in Illinois some years ago. I started out my career in the state legislature, and after 2 or 3 terms in the legislature, we ran into a year that we were supposed to reapportion ourselves in the legislature under our state constitution, and we had failed to agree on a reapportionment map. And under the provision of the Constitution, every member of the House of Representatives in the legislature had to run at large, which meant we had a ballot with 236 names on it. It was 3.5 feet long. And it was terribly confusing to everybody. But the only good thing out of it was that it brought some groups into the political arena that had never been there before. And I got a call from a garden club in one of the north suburbs of Chicago who asked me if I would come out and explain the long ballot to them. And the woman who called me said, "Now, Mr. Mikva, we're a not-for-profit, nonpartisan group. Please don't come out and make one of your political speeches." I promised her I'd be a good boy, but she obviously didn't take me on face value, because her introduction went something like this. She said, "Now, Mr. Mikva is a member of the blank political party. And in the last session of the legislature, the blank political party had 85 members in Springfield. And Mr. Mikva was one of the biggest blanks down there." I'll try not to be a blank, but on the other hand, I will try to park my big D outside the door. What about lawyers as president? We've had a lot of them. Overall, 57% of the presidents have been lawyers. That's a very impressive number. It's a little less impressive when you break it down by time. Until 1900, 71% of our presidents had been lawyers. Indeed, until the 1900 election, every president who was elected from the beginning of the country until 1900 was either a lawyer or a soldier, with one exception. Vice President Johnson, who was elevated to the presidency when Lincoln was assassinated, was a tailor. And he suffered a very ignominious, and as you may remember, by being impeached, almost removed from the presidency, and was sent back to his tailoring after a very brief and unsuccessful tenure. But everybody else was either a war hero, General Washington, General Taylor, General Jackson, or they were lawyers, the Jeffersons, the Adams boys, the Monroes. Somehow, starting with 1900, the cachet of lawyers as president began to dim. And since then, since the 1900 election, we've had only 7 lawyers out of 17, 37%, as against 71% before then. And what's more important than whether they were lawyers or not, that we should know from Calvin Coolidge that just being a lawyer doesn't necessarily make you a great president. But the fact of the matter is that the 7 that we've had in this country, in this century, have all had, not all, but have had a continuing disconnect between their being lawyers and being president, with the first 2 exceptions. Woodrow Wilson and William Howard Taft were both lawyers. They both had great credentials as lawyers before they were elected president. And they took the rule of law and their legal responsibilities seriously in their role as president. Woodrow Wilson certainly observed the rule of law and expressed his concern about it, and is trying to fashion a treaty at Versailles and trying to sell the League of Nations to the American Congress and to the American people. It was important to him clearly that a serious view of the law as an instrument of justice, as an instrument of our foreign policy and our domestic policy, was very important. He came by those credentials naturally. He'd been a professor. He'd been president of Princeton University before he became governor and then president, and he came by those credentials naturally. The same is true of President Taft. He had been a law professor. He'd been dean of the University of Cincinnati Law School before he was elected president. Indeed, after he was through with his presidency, he became Chief Justice of the United States. He took the rule of law and his concern about the law seriously. But unlike Wilson, I have to admit that there are pieces of his administration and his life that fall closer to the Coolidge model than the Wilson model. I defy anybody in this audience of lawyers
to name one important precedent that Chief Justice Taft handed down while he was Chief Justice, or one important doctrine of law that President Taft was responsible for while he was president. Now, I admit I haven't done exhaustive research on it, but I was unable to find a Taft doctrine or a decision of the Taft Court, the equivalent of a Brown versus Board or a Roe versus Wade. He may have performed as a lawyer, but he certainly wasn't at the top of the ranks of his contributions. Then we come to modern times, at least modern times for me. I was born shortly before Franklin D. Roosevelt was elected, and I grew up on the notion that he was president for life. And I guess I knew he was a lawyer, but it was never an important part of his credentials. I don't think he ever practiced law. If he did, it was for a very brief period of time. And indeed, the troublesome part of Roosevelt's tenure, and you have to remember that I'm a Depression baby, I'm a yellow dog Democrat, so I am not about to stand up here and tell you that Roosevelt was anything but a superb president. But it did not include his role as a superb lawyer or as a superb constitutional practitioner as president. For example, early in his career, early in his tenure as president, he found the Supreme Court's decisions not to his liking, and he proposed a court packing plan. Not necessarily unconstitutional. Our Constitution provides for ups and downs of the number of people that are on the Supreme Court, but clearly an effort to overturn the decisions of the Supreme Court in some way other than the constitutional plan, the constitutional path. He was unsuccessful in that. That was one of the few legislative failures that he had during his time. But there were other examples of his nonchalance, I guess is the nicest word I can say, about the rule of law. When he was told that because of the Embargo Act that had been passed by the Congress, he couldn't provide aid to England in its time of strife with Hitler before we got into the war, he evolved something called the Lend-Lease Plan that went around the constitutional prohibition. And unfortunately, he was like many other presidents, including a couple that I served under or with, who looked on the Constitution as an obstacle course to get around and get over as president, but never to take seriously and never to look to as a means of furthering our democracy or our sense of justice. And so when you look at Roosevelt the lawyer, and I cannot help but add that he saw no problems in approving the proposal of the West Coast general who suggested imprisoning all of the Japanese Americans on a possibility that they might be threats to the country. It never occurred to him that something like the writ of habeas corpus should allow those people to be their cases reviewed, nor did it occur to him that the presumption of innocence and the freedom guaranteed by the Bill of Rights was being seriously violated by his edict. He went ahead and did it. The same is true, unfortunately, as we go on further with lawyers as president. The next one in the line in this century after Roosevelt is Richard Nixon. Now, Richard Nixon, I have to admit, was a pretty good lawyer. He was a Duke graduate. He practiced for a very short period of time before he went into Congress. But again, for him, the law and the Constitution were obstacles. You get around them. You don't pay any attention to them as important doctrines that need to be observed. It wasn't only his personal behavior. Again, it was his attitude about the Constitution, about his use of the power as president that went way beyond what the constitutional strictures would have suggested. And Jerry Ford, my dear friend who came from this state, and who somebody I liked and admired and served with in the Congress, would be the first to tell you that he did not consider himself a great lawyer. You recall that in one of his early speeches he said, "I have to remind you, I'm a Ford, not a Lincoln." And I regret to say that it was true. Jerry Ford was many, many things, and he did many great things for this country. But his understanding of and respect for the Constitution and the law was not that outstanding. One of the personal experiences I had while he was in the House with me was that he had taken a bee in his bonnet that Justice William O. Douglas should be removed from the court. You may recall Justice Douglas had been involved with some foundation, not in any sinister way, but in some way that violated the canons of ethics, and Ford was determined to impeach him and get him off the court. Well, the Democrats controlled the House Judiciary Committee pretty heavily at that point, so he couldn't get an impeachment resolution through the committee, but he devised a parliamentary procedure whereby he could call it onto the floor, even though it had not come through the committee. And another congressman and I, who were on the Judiciary Committee, were assigned to answer Congressman Ford's efforts to impeach Justice Douglas from the floor of the House. And our big issue at the time was needling him about what is an impeachable offense. You will recall that the Constitution says an impeachable offense involves high crimes or misdemeanors. Well, even Jerry Ford knew what a misdemeanor was, and we said, well, a misdemeanor is a parking offense, Congressman. Are you suggesting that if a officer, or the federal officer, like a Supreme Court justice, is guilty of parking offenses, he can be impeached? And he hemmed and he hawed, and he allowed that it would have to be a very serious parking offense before it could come up to an impeachable offense. And then finally he said something which at the time we hooted at, but after my experiences with impeachment later on in my career, I began to realize probably had more sense in it than I thought at the time. It may or may not be good constitutional doctrine, but then there isn't any doctrine on what is an impeachable offense. What Jerry Ford said when we were finally had cornered him on whether it included misdemeanors or not, and what kind of misdemeanors, he said, I'll tell you what an impeachable offense is. An impeachable offense is anything that 218 members of the House say it is. And you know he was right. Because as I found out in the Clinton matter, which I was not formally involved in, but I was involved, there aren't any real charges that do make for an impeachable offense or don't make it for an impeachable offense. The impeachment comes from the political mood in the country is so upset with the sitting president that it reflects itself in the House of Representatives, the people's house, that they are prepared to interrupt the set term of that president and impeach him. And what is that kind of offense? It can be something as insignificant as a sexual dalliance, and it can be something as important as taking us into a war that we shouldn't be in. But in any event, it's for the people and the House to decide, and trying to put legal dimensions on it has never made any sense. Well, that was Jerry Ford's contribution to the law. I must say, for all the things he did right, he won't go down in history as one of the great legal scholars who occupied the presidency. And then we come to the next and last president in the line, my former boss, William Jefferson Clinton. I have to start out again by saying that I worked for him for over a year. I admired him. I still admire him. I wish he could speak a little more clearly about who his choice is for president currently, but other than that, I have had the greatest regard and continue to have the greatest regard for President Clinton. But he was not elected as a lawyer. And in moments of candor, he would be the first to tell you so. Every once in a while, when we would get in a debate about something, he would remind me that he had taught constitutional law at the University of Arkansas, but that was for one semester while he was between the terms when he lost when he would run for Attorney General and was running for governor. He never took the law seriously. He never practiced it. And I will cite two examples that particularly bothered me during my tenure. Actually, only one of them was in my tenure, but the other I was involved in. That continued to bother me that President Clinton did not take his legal obligations and his legal training seriously. The first was habeas corpus. I was pleased that Judge Keith, somebody I greatly admire, and I congratulate you for honoring him, wrote this vigorous dissent in a habeas case. You know, habeas corpus is called the Great Writ for not for any trivial reason. It precedes our Constitution. It was one of the great pillars of freedom that the Lords wrested from King John, and it has remained an important pillar of a just society ever since then. Sadly, it has been eroded and diminished almost beyond recognition in the last 20 years or so. And I certainly don't want to blame this all on the last 30 years. I don't want to blame this all on President Clinton. Indeed, he initiated very little of it. Much of the initiation of the assault on habeas corpus came during the Nixon administration, came during the first Bush administration, and it was driven as much by the opposition of sitting judges to habeas as anywhere else. Chief Justice Rehnquist appointed a commission, the Powell Commission, that spent many months and wrote many pages saying how habeas was cluttering up the federal courts and that we had to do something to curtail the use of it in so many cases. And a great job was done, frankly, by the lawyers who did use it excessively in diminishing its importance. President Clinton had been Governor Clinton. What he saw of habeas was not that of a criminal defense lawyer. He saw it as a governor watching all these people on death row, languishing there for years and years and years as their aggressive defense lawyers filed one writ of habeas corpus after another. And as far as he was concerned, he agreed with the critics that habeas was just cluttering up the courts and cluttering up the legal system and wasn't performing much of a role. So that in 1995, when I was White House counsel, the Congress was proposing a new Patriot Act, a new Anti-Terrorism Act, it was before the Patriot Act, in which they were virtually going to wipe out the last of habeas corpus. It was almost going to be impossible to bring a habeas corpus case in the federal courts. And it was moving along pretty well, and we knew that the President was leaning toward it because, again, that was not one of his things. The Legal Defense Fund of the NAACP at that time came up with what I considered a very ingenious answer to the problem. They provided in a bill that every petitioner seeking habeas corpus would get one opportunity in federal court so long it was brought within a year of the final judgment from which habeas was being sought. And in that petition, they could raise all questions of law or fact that could otherwise be raised. I thought it was a great solution to the problem. It would eliminate these excessive delays that President Clinton was complaining about. It would make sure that we weren't just using habeas as a delay technique that was not being used frivolously, but on the other hand, it would preserve the great writ for the cases it was needed. And Henry Hyde, my old friend from the Illinois legislative days, was then chairman of the House Judiciary Committee, and Henry and I disagree on other issues. He's a very good lawyer, and on civil liberties type issues, he was usually at least willing to listen. So I took the proposal up to him and showed it to him, and he read it. And he said, well, Ab, I could be for that. Have you got a client who's for it? And I laughed, and I said, no, but I'm working on it. And I went back to the White House and gathered my staff, and we had great bargaining power at this point. So we prepared this very thorough memo to the President explaining what was going on, and that Chairman Hyde had indicated he would support it, and that this would solve the problems without wreaking havoc on habeas. And we sent it in waiting for that left-handed check mark, which would give us the go-ahead. Unfortunately, it was at the same time as the Oklahoma City bombing. It was right after the building had been bombed in Oklahoma City. We hadn't yet caught Mr. McVeigh. We were still chasing Arabs on the conviction that some Mideasterner had done the dirty deed. And a delegation came in from Oklahoma, headed up by the Oklahoma Attorney General, to meet with the President. And their message was that the worst problem before the country at that time was to get rid of habeas corpus, because if they caught whoever had done it, it would be terrible if that person languished in jail for years and years and years because somebody was filing habeas corpuses. And after the Oklahoma City delegation met with the President, I received a call to come in and see him, and he handed the memo back to me. He said, no, I'm going to let the Congress work its will. I'm not going to get involved in this thing. It's as bad as I thought it was. And that was the end of habeas corpus as we knew it. Again, I criticize him not in the judgment on whether whether it was a good idea politically or a bad idea politically. It bothered me that he did not see that it was worth any chits to try to save the writ of habeas corpus. And the other incident that came up, and this was after I left the White House, but has continued to bother me even to the point where I have mentioned it to him, and it's never easy to tell the president you didn't like something he did, was his pardon of Mark Rich. And I'm not talking about the other pardons, not of his brother, not of Dan Rostenkowski, not of all the drug people. Those are the ones that are clearly within the purview of a president who is exercising his discretion to decide who should be pardoned, who shouldn't. Mark Rich stood in a different category. Mark Rich was a fugitive. And those of you who have practiced criminal law know that there is a doctrine of fugitivity in this country that says that no one in law enforcement can help anybody who's on the lam. I was reminded of the doctrine of fugitivity when I was a chief judge. I had written an opinion, great opinion, that has never seen the light of day, because it involved the right of a defendant at St. Elizabeth's, which is our criminal mental hospital in Washington, D.C., to challenge being forced to take mind-altering drugs. And this prisoner case had been brought by some organization to challenge the right of the authorities to force him to take mind-altering drugs. The question has been somewhat resolved since then, but at that time there were no precedents on the books, and I wrote what I thought was a great opinion. And about a week before I was scheduled to come down, I had my court. The two were in agreement with me. I got a call from the Department of Justice that said, Judge, you can't issue that opinion. And I bristled and said, why? You don't tell Article III judges what they can do and can't do. And they said, well, the prisoner escaped last week, and we don't know where he is, and therefore you can't issue it. And they cited me the cases, and sure enough, when I looked them up, there's no wiggle room. It's very clear. Anybody in law enforcement, be a prison official, a judge, or the President of the United States, the Chief Magistrate, cannot help anybody on the lam. Mark Rich was on the lam. President Clinton was told these problems and the doctrine, not only by me and by others, but by people who were close to him, on his staff, his chief of staff, his closest friend at the time in the legal profession, Bruce Lindsay. All of them begged him not to sign it. For reasons still unknown, he signed the pardon, and I think indicated a disdain for the rules of law, which I expect lawyer presidents to observe. Well, that brings me to the question at hand, on which I have to be even more delicate. Just suppose a lawyer gets elected president on November 4th. Now, no names, but assume a lawyer gets elected president on November 4th, and suppose he's someone who has taught constitutional law at the University of Chicago Law School before this, and suppose he spent 10 years doing that, and that before that he had gone to a very prestigious law school where he had been recognized, where one of the law professors was also very well known, said he was the brightest student he's ever had. I wish I could get that kind of praise from Larry Tribe. What kind of a president would he make? Well, I think that the difference between Barack Obama, I may as well mention his name, and other lawyer presidents before, is that Barack has the judicial temperament, if you please, to recognize that the rule of law is supposed to be a restraint on lawmakers and lawgivers. That it is supposed to be an obstacle course, but not one that you try to evade, but that you try to follow. I'd like to think that when it comes to the appointment of judges, he would recognize that the appointment of judges may be the greatest legacy that a president has. Our Supreme Court has fallen in dismaying standing as far as the rest of the world is concerned. I remember when I first came out of law school and started doing any travel abroad, I would find that judges in every other country in the world would be able to quote our precedents and talk about our great legal heroes like Holmes and Brandeis and Cardozo and John Marshall. And our court has lost some of that luster because there are judges on there who think that we shouldn't even be involved in looking at what legal precedents are and what the rule of law is internationally. I think that President Obama would care about those things. I think he would recognize that that is part of the great legacy that we can give the world is our respect for the rule of law and the distinction of the people who make and interpret our laws. There are lots of other places that I think a lawyer president would be a good idea, not just because of my own obvious bias and partisanship in this particular election, but because I think that lawyers are uniquely equipped in their 3 years of law school and in their practice or judicial presence or their presence in academia afterwards, that they are uniquely trained to handle the most awesome job in the world, that of being president. I think they recognize the need to listen to other views, the need to respect other views, the need to treat other views with civility, and to try to find a consensus on issues rather than try to bull them ahead with brute force. It's not easy for lawyers to play that role in government anymore. We don't enjoy the great reputations of the Thomas Jeffersons and the John Adamses that they had. But on the other hand, lawyers have always been in some kinds of trouble with the body population. We either know too much, or we think we know too much, or other people think we know too much. But in any event, we aren't the most beloved, fuzzy creatures that our neighbors can find, and they treat us that way. And maybe I ought to close by telling you one of my favorite stories that comes out of Chicago practice. In Illinois, the lawyers are still allowed to handle their own voir dire. The judges can get involved, but basically the lawyers can pre-try their case on voir dire, and they do. And this one woman marched into the jury box with a very angry look on her face and sat down in the jury box, and the first lawyer got up and he said, "Well, now, madam, I'd like to ask you a few questions to see whether you have any biases or prejudices in this case. My name is Abner Mikva. I'm the attorney for the plaintiff. Do you know me?" She glared at him and she said, "Of course I do. You're a crook." Well, he was a little bit taken aback, but he thought he'd spread the glory around. He said, "Well, over there sits Lisa Brown. She's the attorney for the defendant. Do you know her?" And the woman glanced at Ms. Brown and said, "Of course I do. She's a crook, too." At that point, the judge called a short recess and beckoned both lawyers up to the bench and whispered to them, "If either one of you asks whether she knows me or not, I'll hold you in contempt of court." I'm not sure that a President Obama can cure the cynicism of all of our apocryphal lady lawyers, but I think he'd try. Thank you very much.
Anyone must have a question for the judge. Go ahead. Abe?
This is related to Chicago and the Gerald Ford. One of the things I always thought that Gerald Ford did that did give him stature in the district was when he cleaned up the Justice Department by appointing Edmund Leakey, who was the Dean of the University of Chicago Law School. And I'm just wondering whether you agree, disagree, and why.
I do agree, and I think that it was one of the finest acts that President Ford did. He recognized how deeply flawed the Department of Justice had become. I mean, how much flawed can you get when the Attorney General is being able to explain prison reform firsthand because he's been there, like John Mitchell. Pardon?
We have other candidates for that.
That's right. And clearly Edward Levy was a superb Attorney General, and he did clean up the department. And it lasted for a long time. Unfortunately, you can't, just an Attorney General, important as an Attorney General is, cannot create a lasting structure that will survive the pratfalls and pitfalls of future political demonstrations. And frankly, one of the reasons I'm concerned about our country these days is that I feel the Department of Justice is on serious problems at this time around again. When you've got problems about whether or not the ex-Attorney General has been candid in answering questions that the Congress presented to him, when you have U.S. attorneys being forced out of office because of their not even their political views, because of their unwillingness to respond to pressure that's been put on them by political people, I think it's a department that's in serious trouble. And I think it's going to take somebody very good and somebody very committed, and hopefully a president that's very committed to cleaning it up. But your point is well taken. It was one of the many good things that Jerry Ford did for his country.
David?
Judge, you have a wealth of experience politically, at the state level, at the federal level, and judicially. I have a very serious question for you. It seems to me after anarchy in the early part of the last century, we had Sacco and Vanzetti. After Pearl Harbor, we had the roundup of the Japanese. After 9/11, we have Guantanamo and we have Tonga. Suppose we were the victim of some more serious attacks from Al-Qaeda. Do you really think that we as a nation have what it takes politically? Do we have the wisdom to keep this beautiful document and this set of procedures and protections that we have? Or do you think we throw it all away out of fear?
I hope we would. I wish I could give you a stronger reassurance than that, but there's no question that during those times of that kind of crisis that you described, the first thing we reached to do is to throw away the very liberties we're claiming we're trying to protect. It happened with the Patriot Act after 9/11. It happened with the Japanese Internment Act after Pearl Harbor. It has happened every time in our history. When the Russians were a threat, we were willing to let Senator McCarthy trample over precious, important civil liberties. It's a fact of life that the American people are very quick to discard or diminish their liberties in order to preserve their order. The fact of the matter is, as your question suggests, you can't have one without the other. You can have order, but only in a dictatorship without liberty. If you don't have the liberty that it takes to let free people voice their ideas, you can't begin to enjoy the fruits of democracy. I still remember that Jefferson once said that if he had to choose between a free press and free elections, he'd choose the free press because he couldn't have one without the other. And in a sense, he's still right. Without a free press, no matter how biased we think they are when they come out for the other guy and the one we're supporting, we couldn't possibly survive as a democracy. And unfortunately, every time we get in serious trouble, there's a tendency on the part of people within our society that Congress is unfortunately too quick to jump to agree with, who say we got to tighten down on civil liberties, we got to get rid of this, we got to get rid of that, we got to get rid of habeas corpus. That's the problem. Well, I don't know of a time when too much liberty has been the problem in the United States. Thank you. Thank you very much. Yes. Oh, he was a photographer. You're forgiven.
Thank you, Judge. Well, that concludes our third annual, and drive safely, and we'll see you soon. Bye-bye.